expect me to react. I know I'm jealous and fool and easy to lose my temper, but call me back here.
Still not get tired.
Hey, girl, think me have to call your phone? You know who you are deal with? You think I want to lick me again next time? Eh?
It doesn't have to be this way. You can leave an abusive relationship. Just call 876-553-0372. We will help you.
Motorists, as Minister of Justice, I appeal to you, obey the road code, pay your ticket on time, and only go to court if the ticket is being contested. Close to 80% of matters coming to the parish courts are for traffic breaches. Let's work together to make our roads safe and ease the burden on our courts.
I wonder who that somebody be. No, sir. Let me look for my glasses. Oh, that somebody look like right, sir. It's Lottie, walk on. Me glad for see you, right? Although things never go on for you, America, me glad to see you there.
Yes.
Lift your head high.
Yes.
Stay out of trouble.
Yes.
And you can have a fresh start back home.
All right, Miss Vicky. Thanks, you hear?
Let's all work together for a fresh start back home.
The following is brought to you by the Office of the Prime Minister.
Peace is a choice we make every day. When we come together with love and understanding, we create a future free of violence and fear. Let's stand united, build bridges, and nurture hope for our children and our communities.
Would you want to lead us out in prayer? Thank you so much.
Let us pray. Almighty God, we give you thanks for your mercies that are new each day. As we gather to deliberate on important matters regarding the conduct of the Parliament, I ask that you grant us focused attention, clarity of thought and mind, and a spirit of cooperation in our deliberation. May all that we do be done to your glory and honor. In Jesus' name we pray. Amen.
Amen. Let me first welcome Mr. Sean Kinsey. I hope I'm pronouncing it right, Sean. I will not say Kinsey more than once. So it's Mr. Sean Kinsey. And Sean has been a tower of strength, giving support from his involvement as a member of the team, working for a long time with the Commonwealth Parliamentary Association, doing several of the engagements in training parliamentarians across the Commonwealth, and he continues to support and has spent quite a lengthy amount of time with our own parliament. I'm not sure why Environment, Food and Rural Affairs Committee is behind him, but today...
It just happens to be where I'm sitting. Don't pay too much mind. I found a quiet spot.
Yeah, but today we put into perspective his involvement here. For those who were a part of the training session, you would remember Sean. He was recently here with us with the training executed by CPA and Parliamericals to the extent that we were being trained. We have 3 of our members seated here and others are on their way, with only one apology for absence, a member who is overseas, Mr. Williams, Donovan Williams. Hope the others make their way quickly. So, following on our last committee meeting, we have an extended set of minutes. Has everyone had the opportunity to go through? And if not, because it is so extensive and the discourse was so detailed, I would also want to suggest, if we are of the view we'd like to defer adopting these minutes for a later date, you may so do.
Madam Chair, perhaps later in the meeting, because once minutes are deferred, then they take time in the next meeting and the next meeting to be confirmed.
Yes, I'm hearing you, member. So, member is saying if it is at all possible that we can confirm the minutes later on in the meeting before we conclude, we could do so. If not at that stage, then we defer. However, deferring is not the best option. Compounds the carry forward. Right, so thank you for that. The only matter arising, even though we haven't gone into the minutes yet, is the process of having carried a motion to allow for the work of the committee previously done, including all the work done by Sean and the Parliament in putting this draft set of standing orders together for us to review, has now been carried forward for this committee to consider. So that was done at the last sitting, which I must tell you, Sean, sparked quite a bit of debate.
I can imagine.
I thought it was going to be
I've been in your parliament a few times, so I would expect nothing less.
Thought it was a simple thing to just carry over, but it caused some spirited discussions. And we are happy to now embark in this process. The members at the last meeting indicated before we started dredging through in a very detailed way the new standing orders was to get some guidance from you as an independent arbiter over these activities. You know, the basis that was used. You have assisted with putting together a matrix which would help to guide, and members of the committee have been given a copy of the matrix. It was emailed some time ago, but we have also added a copy to the decks so that they can follow, and it will allow you to lead out over the next 45 minutes or so to an hour to just guide us as to the process first. And if any questions are there, we'd field questions. The idea is that we will separate in our political caucus. The opposition will meet with its members and go through and see separate and apart from the normal process of just taking the report from the committee and the views of the committee to make it a little wider process in engaging both their opposition counterparts and for us from the government side. We do the same so that when we conclude this process at the committee level, we sort of already have a substantial buy-in from the membership of both sides of the House. So, Sean, you may proceed.
Thank you very much. And thank you very much, everyone, for inviting me virtually into your chamber today. As was previously noted, I've spent quite a lot of time alongside CPA colleagues in the last, maybe up to a year now, looking at the standing orders that you have, comparing them to best practice, visiting your parliament on 2 occasions, first in the pre-election period, which was incredibly helpful. It was sort of a quiet time where I could sit down and work things through and get a sense of the space and the provisions that were there, speak to colleagues who work on this frequently, to draft a revised set of standing orders for yourselves, and then subsequently return as part of a workshop to talk those through, at least initially, and to present them to the colleagues that were able to attend the pre-election seminar, post-election seminar. So I think the first thing to say is that I have come to support on this project as an external consultant, I suppose. My experience is working across a range of Commonwealth parliaments, including, of course, Westminster, where I've worked on some major modernisation projects as well, particularly around the standing orders and particularly around virtual proceedings and other areas there. But I've also worked across several other establishments and taken a real deep interest in this as well. So that's the background to me doing this. It's been a pleasure, as ever, and one of the things I would say to the colleagues, the clerk colleagues in the room, but also to the members and speaker that I've been able to deal with, is it's been a pleasure to see the ambition to try and modernise these to a point that they're incredibly easy to use and that they themselves represent best practice across the Commonwealth parliamentary parliament. So it's been an effort of love and one that I'd like to get into. So essentially, this is part of a wider procedural modernisation and technical assistance project for the Parliament. It's come through a memorandum of understanding with the CPA, and it's been approached as a sort of non-partisan institutional exercise focused on strengthening the rules and working practice of the House, rather than in itself advancing any sort of political or policy objective. I identified several areas where the existing standing orders, which were first adopted in '64 and subsequently been amended, had become very difficult to navigate, quite structurally fragmented, and quite often dependent on practice rather than sort of clear textual provision, which has the ability to lead to a lot of time being spent discussing the standing orders rather than applying them in a sort of clean and professional way. So my aim in the project that I've undertaken is to address those issues by organising them into a more coherent framework, consolidating them into related provisions, clarifying authority, modernising rules on committees, questions, technology, public access standards, and introducing clearer procedures where gaps had emerged, so for example around technology. In some cases within these, and I'll get into the table in a moment, the revised draft makes existing practice explicit. So where practices have arisen, which are used and well used, it makes those more explicit and it lays out the groundwork for those. And in others, it introduces sort of procedural safeguards or administrative machinery to reflect expectations around accountability and transparency. So the table that has been circulated distinguishes between changes that are primarily structural, changes that codify existing practice, and changes that introduce more material procedural development. And its purpose is to explain the sort of technical effect of each revision, as well as the wider institutional implications for the operation of the House. So I don't know if it would be helpful at that point to pause and see if anybody wants to ask any questions on the generality before I get into the specifics. I'm happy to go on, but any questions on the background, the approach, the procedure, I'd be happy to take at this point.
They're clear in terms of the procedural background. Just to summarize, especially because you speak English, but still with an accent that is a little different to ours.
Sorry.
So to summarize, Sean is indicating that the draft of these standing orders would have taken into consideration primarily what is standard across all Commonwealth countries that have similar parliaments to ours. And every effort would have been made primarily to reorganize the standing orders so that they flow in a way that is easier to understand, and to also add more in terms of explanatory notes so people don't have to guess at what the standing orders mean, and to also sort of codify some of our practices that were not necessarily documented, but we have adopted them, and it is similarly adopted in other jurisdictions like ours, to write it in to our standing orders so that there is, more clarity and a better way forward. And then he will, once we're comfortable with that sort of a background, he will now go into the matrix that speaks to the actual, what was the old standing orders like, what sections have been redrafted and why, and how it has been repositioned, and the effect of the revision. And he did a sort of analytical summary of the implication, a little commentary on what those revisions cover, would do, how do they apply, what are the implications. Go ahead.
Yes, Madam Chairman. I was just asking whether or not we have permission to tape this presentation, or
it is being taped.
Okay.
It is such an important thing for us.
Yeah.
And Sean, I don't know that any parliament is any less or more bipartisan and argumentative sometimes than ours. I think we are like anybody else. And standing orders can sometimes become a little touchy. It is understood that we are actually, I must also make this point, that we are actually not about trying to just adjust the standing orders on a whim and fancy as we feel, because these standing orders, as has been indicated in the opening remarks, is a representation of what really pertains right across the Commonwealth, across similar parliaments. So it is not about just getting up and doing, just changing willy-nilly. Standing orders are not frequently adjusted, and we have not had any real serious, amendments to our standing orders in a very long time. Where we have had adjustments, it's because of things like accountability and oversight, which has been included by Cameral Caucus of women parliamentarians, which has been added, but we really have just been dropping on when we need to. We drop on here and there. And very often, we have even seen things we'd want to change, but we just leave it because it is not that critical that we would go into the standing orders and amend them, but it really does require that we formalize the process. And we have not done so in the past. So as we go along, Sean, you can break at junctures, so persons, if they have questions, we would let you know. Are you able to see me from where you are?
I can see you, yes.
All right, so if I get any indication from a member that they have a question or want to interject, I'll be the one to wave. So we take a break and allow them to participate. But as asked by Member Paulwell, the session is fully taped so that we will have the benefit of going over and even sharing with others who may want to review. Thanks, Sean.
Thank you. And yes, I agree. I mean, I think as with all standing orders, after a while, they can become a bit of a kind of a Christmas tree where you're hanging things off it and you're adding things over time. But actually, what has been very refreshing about this exercise is the willingness of yourself, Speaker, and colleagues to look at this in the round and think, how can we reduce the number of conversations about standing orders? Standing orders themselves ideally shouldn't be a matter of debate. They should be how you conduct debate. And I think if you're spending lots of time talking about standing orders, it probably is a good reason to have a look at those and see if they can be simplified. So I will kick off with the first section, which I think relates to that. And excuse me, I'm looking over here because I have notes and the camera is here. So just I'm not ignoring or looking anywhere else, but it means that I can be clearer with my messaging. So I think the first thing to say is that the structure has been changed quite considerably. So whereas previously it was kind of all over the place, and in order to work out what was happening, you would be moving to and fro through the standing orders to different provisions. I have, as much as possible, put them into a linear and logical framework. So that's had a comprehensive restructuring and renumbering. I think this was particularly necessary, as you said, Speaker, previously. There's been lots of things added and that relate to each other, and it's not particularly clear how those interact. So hopefully this will make them much easier to navigate, and there'll be a much easier code to work for everyone. So members on both sides, for the Speaker, for the clerk, for the public, and it reduces dependence on informal numbers and informal knowledge. And it also makes any future changes easier because related procedures have been placed together rather than in different parts of the standing orders. I should say I can't see anyone anymore. I can only see myself. So if I won't see a hand go up, but do shout if you want to raise anything. So the standing orders start off now with purpose and scope. So that's a sort of clause 1. It's a new foundational provision, and it explains what they are, what their authority is, and how they'll be applied. It anchors the rules in the House's constitutional power to regulate its own procedure, but also makes clear that the standing orders are subject to the Constitution and do not themselves alter constitutional powers or privileges. So this isn't a kind of a constitutional power grab or anything like that. It's just a reorganisation of the rules, which you're allowed to organise subject to the Constitution. Then we move on to interpretation. So really this replaces a narrow residual fallback as to how they'll be interpreted with a more systematic interpretive framework. So what happens when there's any dispute, how gaps and ambiguities and unforeseen cases are to be handled, and strengthens the chair's role as the interpreter of procedure while preserving reference to parliamentary practice that you might want to refer back to. But I think one of the things that was particularly notable in the standing orders was there was lots of reference back to this place, to the House of Commons, that may have been relevant some years ago, but are increasingly irrelevant. And so wherever possible, those have been moved and rooted in broader Commonwealth practice and also in practice that has developed in Jamaica. And alongside that, I think is clear, which isn't so much part of the standing orders per se, but it's that the language throughout, for the same reason as the interpretation and the same reason as the scope and the structure, has been simplified considerably. It was quite old-fashioned, and it wasn't necessarily clear. There was a fair amount of ambiguity there, and so the language has throughout been modernised as well. So it is less gendered, it is more general, and it is hopefully clearer to use. So that was a big part of the exercise. Is, there aren't that many new provisions, not very few provisions have been removed, but actually a major part of the whole exercise was making it clear and easy both in structure and in language. So moving on then to how the orders would be changed. So you're looking at clauses 4 and 5. It brings the core rules on suspension and amendment into the general framework of the standing orders now. So I know there is a practice of temporary suspension for a particular purpose. So, moving to suspend the standing orders, it makes it clearer how that operates, and then also how you would formally amend the rules if you wanted to. So hopefully that would improve the kind of procedural certainty while also protecting the rules in themselves. I mean, hopefully using the way these rules have been updated to reflect actual practice. In an ideal world, you wouldn't be suspending the standing orders as much. Or if you were doing, you might be doing it in a different way in a certain context. So it would provide more structure to the day. Debates can happen faster. There is less debate about the standing orders, less need to suspend because the process is clearer. At least that's the aim. We then get to the duties of the clerk. So it modernises the administrative foundation of the House. So identifying that the clerk and the clerk's team has responsibilities that aren't specific to core chamber functions, but about advising on procedure, supporting proceedings, maintaining records, preparing papers, and all the things that are required, but then being quite clear about how those things will happen. So expectations from members can be clearer about what to expect and when to expect it, which I know can sometimes be an issue. Then looking at Standing Order 2 to 4, then you really have the role of the Speaker, and we get into the point here, and there's a fair amount of clarification about the Speaker's role, which retains the broad substance of the existing provisions, but is more coherent about the role of Speaker, Deputy Speaker, how election would happen, absence happens, vacancy, how authority is designated and delivered, but it doesn't make any sort of major substantial change to the constitutional position of the Speaker, but it just clarifies what those roles and responsibilities are. And this is very much a kind of best practice Commonwealth thing that I've brought in to make it clear about what the role of the Speaker is and isn't, and how those rulings should be put down and applied. And again, it comes in clear about the Speaker's authority to interpret and enforce the standing orders, regulate procedures, maintain order, and decide procedural questions as well. So hopefully it reduces the scope for kind of repeated challenge, and codifies powers that were previously dispersed or assumed. We then did deal with the oath. So, by the way, I'm going in the new orders rather than the old ones. This was previously standing order number 1, but it just clarifies the oath and members taking it, but gives more clarity about the administrative machinery around that. What happens with the role, with vacancies, with by-elections, hopefully improving record integrity, and allowing that rule to work better throughout the entirety of a parliament rather than just at the beginning. So then we get to an area on interests. So this was quite limited in the previous set of standing orders, but is more expanded in these, and it makes it much clearer about narrow rules on pecuniary interests to sort of a broader transparency framework. And I imagine when the committee goes through more, line by line or clause by clause, or however it wants to regulate its own proceedings, this might be an area of interest and debate. Again, this draws on sort of best practice provisions from around the Commonwealth and more broadly as well. But it has more clearer duties on the registration, declaration, and disclosure of interests, and how that links with the Ethics Committee, and essentially how that would strengthen public confidence and give members clear expectations about interests that should be or shouldn't be raised and how to deal with those. In clauses 14 to 15, you are then looking at order and how order is dealt with. So it gives a structured framework rather than a small set of chamber rules. The provisions give the Speaker clearer tools for dealing with disorder, obstruction, and misconduct, and make the consequences of non-compliance more predictable. So there is a clear framework for how disorder escalated, right from a please desist to a major piece of disorder and what would need to happen. Again, I imagine this will be an area where members will want to discuss this. It's important. Everything here is important, but there are certain areas that I'm sure members will want to discuss to get it right, because those members may be enforcing or subject to these provisions, and so it's important that everyone is on the same page. Then looking at what was Standing Order 81, now Clause 16, enhanced and constitutionally linked focus on attendance. So clearer processes for recording, explaining, and dealing with absence, and the revision links the standing orders more to constitutional requirements about when an absence becomes a kind of a procedural issue and when not. We then get into a few areas here, and I don't think I massively need to go into detail right now, but we have areas on the dress code, so expanded and modernized, made clearer. Then we think about language again, so how language and what language should be used in an orderly fashion, particularly around dialect and other languages with the permission and oversight of the Speaker. So hopefully this improves inclusivity while protecting the official record of Parliament, an area members may wish to discuss. The use of technology as well. So one of the problems with standing orders is they're often catching up with technology. So I've tried to produce a sort of future-proof framework for example, hybrid participation to an extent electronic devices, recording, broadcasting, and hopefully gives the House more resilience in the case of emergencies and recognises more modern working practices. But as ever in all of these, there is still the authority of the Speaker to regulate that use, so it's not a free-for-all. Again, talking about public access, so this is another area where it talks about how the public, media, and other observers access proceedings, again, retaining the House's power, particularly where security or privilege order requires it. Moving on then to kind of new clause 21 to 22. So this is about voting in divisions. It makes it very clear. And I think a lot of this, as we go through, I'll probably use the word clear more than anything else. It makes the voting process and the decision-making process in the House much clearer, how they're recorded and how we maintain the integrity of the record. This should hopefully reduce disputes about divisions and transparency about how members voted. And then there's a distinct procedural safeguard following this on special constitutional amendments and constitutional treatments for those, codifying thresholds, certification, procedural requirements, and hopefully reduces the risk of constitutional amendments procedures being treated as ordinary legislative business. So there's a bit of a distinction there. Shall I continue? I'm conscious I can't see the room, so I don't know if a hand has gone up.
No, you can go right ahead. When we need to interrupt, we will do so. We heard you. So Sean is looking at himself. He's not seeing us. But if a mic comes on at a critical juncture, we'll indicate. Members listening in so far, are we comfortable with the explanations being given as we are going through the matrix?
Yes, I think he's doing so well that it would be good for us to go through his presentation because there are questions that will arise.
Member Malahou for it.
Seeking clarity, Madam Chairman, this is not intended to substitute for a discussion on the proposed orders.
No, this is intended to open our discourse. So this is establishing the basis, what was done, what jurisdictions one would have relied on to pull information together to sort of codify and standardize what the standing orders are across the Commonwealth. And this discussion with Sean is really to establish the base and help us to be better guided in our own discourse, internal debate, and ultimate decision as to what we would like our standing orders to finally be at the end.
Yeah, so I should add to that. This is an overview of everything that's happened. But as I said a couple of times, there are really important discussions. You know, these are the rules that govern order and process and legislation running through the House of Representatives. So I would imagine there'll be a considerable amount of more conversation rather than a quick run through, which is what I'm doing now. But now the intention is just to give that overview of what's happened and what the intended changes are, and hopefully to give a sense in the whole of what this is trying to achieve. And what will hopefully be the outcome. So in which case I will carry on then. So then moving into clause 24, so that's around quorum. And I should say, hopefully you can see as I go through, these now follows a more logical path than how the standing orders used to work. So quorum area retains the basic quorum rule, but modernizes its operation, including around potential virtual participation or how quorum might work in emergencies, supporting continuity of parliamentary business, but maintaining the importance of it as a constitutional and procedural safeguard. We then get into issues around sub judice. This has never really been expressly codified, I think, but it relates to the procedural boundary around references to matters in the court. So this is a really important element about how you don't unduly influence court proceedings while you're in the House. And it gives clearer guidance about that. So how justice can be protected, while also giving clearer guidance about how the Speaker can rule about what is or isn't permissible in that area. And that really is drawing from jurisdictions across the Commonwealth and sort of bringing that into the Jamaican context more specifically. Then again, we're moving into following sub judice, the matter of privilege. So questions about how privilege matters should be raised and assessed. It gives a clearer route, I hope, for members to bring privilege matters before the House, and hopefully also helps the Speaker, any time, or the Chair, how to distinguish between a genuinely privilege issue from an ordinary political or procedural complaint. So how those are distinguished and how they'd be handled differently. We then get on to sittings. So this has been sort of reframed, expanded, and supplemented slightly. It retains the core framework for ordinary sittings, but then modernizes the drafting and places special sittings within a clearer structure. So again, this is sort of catching up with how things happen, rather than having a false reality in the standing orders that requires to be suspended or ignored. More provisions there on prorogation, dissolution, and the kind of constitutional life of the Parliament. So it improves certainty about what happens to business at key transition points. I think this is a good example here of where, if you are a member of the House and you have been for a while, some of these things will seem quite obvious, but new members maybe less so, and the general public even less so. So this is where you're making the House more transparent about how it operates, and providing that kind of one-stop shop of how the House works and its rules. On to 32 then, we're looking at the order of business. So this sort of maintains the substance of the existing order of business, but presents it in a more clear and accessible sequence. So it will help with the preparation of the order paper, but it also makes it clear about how business will proceed. I think the previous orders aren't particularly clear, so this is really where we have applied practice and what members are essentially expecting to happen, rather than what would otherwise happen. It's for a House, it's for the government to regulate itself and its order of business, and that wasn't necessarily reflected in the previous standing orders, which I hope it is better now. Then looking at adjournment, so adjournment provisions have been brought together. This is a consolidation into the sort of broader framework of the standing orders. Hopefully this makes things more readable and a clearer distinction between an ordinary adjournment debates, and procedural motions relating to the sitting of the House. So it sort of brings those things together and then makes more clear how they are different. Ministerial statements, the standing orders on those have been refined and integrated, I would suggest. So statements are brought into the broader framework of the order of business. It retains the ability for ministers to make statements where they're clarifying their kind of position, but it makes it clear, and it gives it clear about how that works and the relationship between statements and questioning and how those two interact. On petitions and papers, this is a minor expansion and clarification, so I would say it modernizes the rules for petitions and papers, setting out clearer routes for how those are submitted, presented, and then published, how they're accessed, the form in which they need to be sent in and put out for members. And hopefully this has the benefit of improving transparency and record keeping without fundamentally changing any of the rights to present petitions or lay papers. It makes it clear about how one would go about doing so. On questions, again, this is a series of clauses that have been streamlined and consolidated. These are the old sort of 14 to 17C, now looking at 37 to 4. But this brings again together a fragmented set of provisions into a single questions framework, clarifying things like notice, admissibility, supplementary questions, written and oral questions, urgent questions, speaker's role in those, and then making the scrutiny function through questions easier to administer and understand. And again, a similar point here with motions, where the existing rules on motions have been maintained in substance, but they've been separated out a little bit and sequenced, and hopefully that's clearer. Again, this is an area, and you'll see this as well with bills and financial procedure and other areas, where it hopefully improves the procedural accessibility, really giving you a paint by numbers approach to how you would work through from the beginning to an end of a motions and debates and outcomes, preserving members' rights at the same time. But there's some more clarity about timings and process there. On bills, so there's been a bit of an enhancement rather than an addition, I think I would say here. So legislative procedure has been, the main purposes of legislative procedure are common across the Commonwealth and common across jurisdictions. But I think particularly here, there's a sort of a clearer treatment of certain areas. So, for example, carryover, lapsed bills, improving continuity between sessions, and making clear about the state of legislative business at prorogation or dissolution. But again, it gives you that sort of process of a bill in a way that perhaps wasn't previously there, making it easier for new members, the public, and current members to debate and discuss and decide on the core business of Parliament. Financial procedure then, so we're looking at 62 to 65. This is enhanced and clarified, so it expands and clarifies the rules governing financial business. So we're looking at estimates, appropriation bills, related financial motions, and I'm hoping that this improves the alignment between parliamentary control of public finance and the practical procedures by which financial business is considered. So one of the main or core tasks of Parliament, if you really break it down, is money, authorisation of, and hopefully this makes it clearer and easier to understand in again, many of these are as much as possible almost put through a time sequential process where you would work through in a certain way and you would get the right outcome at the end. So committees then, a lot of work has been done on committees, not necessarily to change them, but to make it much clearer. So previously you had 73, 68 to 80, 73, A to E, and now there's much more in it. So they've been reframed and restructured, replacing a list-based and alphanumerically framework with a more functional system. So the revised draft, I hope, clarifies committee types and membership, chairing powers, evidence powers, reporting, publication, regulatory oversight, and in so doing, I would hope, gives a sort of stronger and more adaptable procedural foundation for committees and how they operate. But again, I would dig into those, particularly if you're on those committees, to see how they are. But it thinks about general powers and then specific powers and specific conditions by which committees work in. And then finally, of this canter through, I mean, there are other areas that haven't necessarily been covered right now, but of the key areas, you will note a very significant general definitions framework at the back. There's been a labour of love, and I would say the most comprehensive of any set of definitions anywhere in the Commonwealth. And really this is to focus on interpretation again. So where there are issues around interpretation and implementation, or discussions around them at least, this has really clarified what everything means in the standing orders, and it can be referred to, and indeed is referred to in the standing orders, to give them effective power. So this is the definition according to the House of Representatives. This really is to make the rulebook hopefully much easier to apply, as long as they're used in the kind of terms using the operative provisions. So that's a big piece of work. I'm sure people will have comments on that as well. Hopefully not controversial, but again, it talks to that whole point, which I hope I will sort of finish with again, which is this exercise has been primarily to make the orders that you have clearer, easier to use, less debatable because everyone is on the same page about what things mean, and then easier to apply, allowing more time to be spent on the core business and less time on the application of standing orders. So that is my run through there, Chair. I'm very happy to take questions. You've heard a lot of my voice, and hopefully that was clear. I know there will be more discussion needed on many, if not all, of the points that I flagged today. But hopefully that gives a good overview of what's been done and why.
Thank you very much, Sean. Most appreciated. Everyone listened attentively. We will now field questions. Before I do so, one of the questions asked prior, and an observation from a member, we have not gone in and made changes to timelines of what we used to do before. And let me use one example. a member that doesn't attend Parliament at all, currently it is very difficult for our standing orders to in any way sanction that individual, because it requires that you have been absent for 6 consecutive sessions within a period of 21 days. We have left it as it is. Even if we are of the view that that should be tightened, we haven't made any adjustments to our existing standing orders, removing any privilege that we had before. So if we thought that 45 minutes was too long for presentation, it is still there. Those are the things that we know as a committee, having concluded the process with Sean and getting an understanding, we'll still have to go back to make decisions as to what we may want to adjust further. Thank you. Member Paulwell.
Thank you very much, Chairman, and can I join you in expressing appreciation for the work that was done prior to now and the presentation, which provides a good overview and comparative analysis as to where we are here. So I just have a few questions, and probably instead of pausing, I could just go through my list so that I won't have to hug the microphone. Firstly, you have indicated that this is a comparative work done looking at the practice across the Commonwealth. And in that regard, I want us to come back to the focus that we practice the Westminster system. Are we, in any significant way, departing from the Westminster system and also those standing orders that the British Parliament now enforce? And if you could say that this is a model of a predominant model of a country in the Commonwealth, would you be able to isolate such a country, or this is just the conglomerate acting as you have determined? So that's one question. Secondly, I know that judges have been loath to interfere with the running of Parliament, but are you aware of emerging jurisdiction in terms of the courts and whether or not they have in any jurisdiction interfered with and provided jurisprudence, case law, in relation to the running of any Parliament, including the British Parliament? Thirdly, we see in this new draft, as also in the current draft, the provision for the suspension of all of the standing orders. So these are rules that govern us, but at any time, a motion can be moved for their suspension. Are there principles that govern? And I know that our aim is to make our standing orders so much more certain. But if you are able to suspend them, then the issue of certainty falls away. And perhaps you could give us what is the standard that is applied across the Commonwealth. And right, those are my questions.
Wonderful, thank you, and thank you for engaging so much with the presentation and the work. So on the point around comparative work, so I would say this is fundamentally a conglomeration of various people's work. You'll be aware that Trinidad and Tobago a short time ago did a pretty comprehensive rewrite of their own standing orders. And having visited Trinidad on several occasions once to sort of work on standing orders and attend a conference there, that seemed like a good place to start. So certain of the provisions have been taken as an example of sort of best practice in a Caribbean context. That said, actually, they've really been drawn across from across the piece. All, I should say, very much Westminster system, built on the framework you have, being sensitive to the specific conditions of the Jamaican Constitution and the practice that you have. But this has been pulled from several areas. So this isn't a cut and paste from somewhere else. I took some inspiration from the Trinidad and Tobago work because they had taken a reasonably novel approach of being much clearer and almost starting again with the standing orders and saying it's got really confused. We agree with it. All the principles are the same, but we are going to kind of work through more methodically and make it easier to access. So that was a starting point, that sort of model of clarity. But really, this has been drawing what I would consider to be best practice from across the Commonwealth, and not necessarily from Westminster itself, which I would say is the standing orders would do well to look at these a bit about being clearer and more accessible to the public. But you'll appreciate that there can often be resistance to that. So, yeah, this is very much from a Westminster system based, looking at similar countries or nearby countries that have gone through this exercise of modernisation. I think, as the chair mentioned before, one of the challenges or opportunities, I suppose, with your particular jurisdiction is the lack of change there's been for such a long time. So rather than it being, and there have been amendments, I'm conscious there have been amendments and additions, but it meant there was quite a lot to do to get them up to scratch, so, or to modernise them and make them clearer. So that provided an opportunity to do a bit more. So I would say these as printed would be some of the most sort of forward-looking standing orders in the Commonwealth as written, not procedurally necessarily, because the procedures are the same, it's still the same legislative basis and it's the same process, but in terms of being clear, simple to access, easy to use, that would be my first response. So comparative with a focus on local countries, but again also drawing on best practice. On the point around judges and judicial interference in the standing orders, so it's a pretty firm constitutional principle that the House has the power to regulate its own business. I must say it's not an area of expertise for me in terms of someone getting involved in the standing orders. Of course, there will always be a tension between, and particularly in countries with a greater constitutional basis than perhaps the country I'm in right now, but in your case where you do have things that are quite firmly established. But in relation to the standing orders, I wouldn't think so. I think it'd be more around powers to prorogue or dissolve Parliament. That certainly happened here a few years ago, but that's not necessarily standing orders. That's more about prerogative power. I mean, one of the things I would say is that what I've very much tried to do in the standing orders is make very clear what the constitutional powers are for different branches of government, how they interact and where they end. So there is much clearer about what it is and what isn't the power. And that's where we have this section before that never happened. We have a section that was never there before on purpose and scope. So that is there to anchor the House's constitutional power to regulate its procedure, but also making clear that these standing orders operate subject to the Constitution and that they don't themselves alter the Constitution. So it's quite clear there. But that'd be my response to that. So I think there will always be a tension, and there's almost a deliberate tension with the separation of powers that we try and maintain in Westminster systems between the executive, the legislature, and the judiciary. But I would hope that these actually, in your context, improve the possibility. And then
Sean,
finally, the provision.
Sean, you have one intervention, Member Malahoo Fort, I believe,
Please.
on something that you would have spoken about already.
Yeah.
So just put a little note down so we don't have you lose your train of thought.
No,
Because
I took notes so I can.
intervention
I'll be
is-
moving on to suspension of standing orders. So, but I'm very happy to talk about the points I've made up until
Go ahead,
now.
Member Malahoo Fort.
Thank you, Madam Chair. On the matter of suspension of the standing orders, it should be noted that what is proposed at the new standing order 4.1 is a repeat of what currently exists at standing order 86. So that is nothing new the existing standing orders provide that any one or more of these standing orders may, after notice or with the leave of the Speaker, be suspended on a motion made by a member at any sitting, and that is repeated verbatim. So to avoid any misunderstanding that the revised standing orders are proposing suspension of any or all of the standing orders, that would not be correct. The proposed orders under suspension operate merely as procedural clarity as to how a motion for the suspension of the standing orders would be addressed. I think it's important for those who are listening on. So the impression is not given that something new is being proposed. It is what exists now, and it's actually what exists in virtually all of the parliaments.
Thank you for that intervention, Member Malahum Ford. Sean, over to you.
Well, I think the question has just been answered substantially with that intervention. Again, and I think as the speaker mentioned before, where there are sort of so the suspension of standing orders is a pretty normal thing. Well, it is a normal thing. You know, the House can regulate itself. It can at any time decide to take a different course. That's a constitutional principle. It's not governed by outside. So if a majority in the House takes a decision to do something, as long as it's not unconstitutional, that can continue. This is very much what is already happening, being brought forward. But I think there's two questions. There is this different? No, it's not. Should it be used less? Yes, I would hope so, because as much as possible, standing orders should work in a way that you don't need to suspend. And I think it's a part of a culture of a parliament or otherwise to determine that. And furthermore, as again I'm sort of echoing speaker and things I've already said, where there are very tricky sort of procedural issues that are not about best practice, they're about a decision of the House and they need discussion. I've certainly not decided that the context in which I drafted the standing orders and worked them initially was a kind of apolitical pre-election. There was no members there. I was in the House. I was working through how things happened. I'd come to visit Jamaica and work on it. So there will be a lot of debate about how some of these operate, and I think there should be, and it shouldn't be for me to say. I think there's areas where there is reasonable debate between the committee yourselves and then onwards from there. But yeah, this isn't a significant change in powers. It's basically moving things across, and as has just been said, as is the case with a lot of things, being kind of clear about if you're going to do that, here's how you do it, and here's how you would talk about it. Anyway, yeah, that's my point.
So
but
you have another intervention from Member Malahum Ford. I'm happy for her previous intervention. I do have a challenge with us having to suspend the standing orders so frequently. And very often it is because we are already, like one of my greatest pet peeves, setting time limits for debate, setting time limits for various elements of our discourse. And we'll set the time limit at 15 minutes. I know the only adjustment I remember, even though it wasn't initially placing the standing orders and later done, was to double the time. And it was say double to 30 minutes. And after that, we were still suspending the standing orders to allow us to speak for 45 minutes and 1 hour. So the essence and the thinking that the standing orders are there but are just absolutely irrelevant to what the House would like to do is something that needs to be fixed. And now that we are in a process of looking at and revising the standing orders, I believe we have to make that effort to have them really work and work in the way that we would want them to going forward for an extended time, so that we are not back here revising the standing orders in another year. Member Malahum Ford?
Madam Chairman, I think the matter of the suspension of the standing orders may be one that we will have to discuss at length. But based on the discussion so far, where a request is granted for a standing order to be suspended, then it is only the order that is suspended. All other orders remain operational.
Absolutely. I think all of us should be very clear on that, committee members. So it would be only that standing order that is being suspended, and only for that one instance that it is being suspended also. To do so again for another situation of the same would require a request for suspension and that being granted.
To go back to the issue of the court's approach and what the research shows in respect of judicially reviewing the regulation of proceedings by the House. So the Constitution grants the House the power to regulate its own proceedings. And as a general rule, the court will not interfere via judicial review in the exercise of that power. In the exceptional circumstances, the extent of the review, as shown by research, is really to see if any rule that apply in its own regulation has been applied. And the more political a decision is, the less the judicial review will be of that decision as a general rule in public law under the heading of judicial review. So that I know even recently in our jurisdiction, our courts reiterated the position that the power to regulate its proceedings is granted constitutionally to the Parliament, and the court will not interfere. But in the exceptional circumstances, the review would be limited to a scrutiny of whether applicable rules have been applied in the own regulation of proceedings.
Thanks, Member. Sean, we are going to go off mic for a second. So off mic, I was just wondering if a decision taken prior not to table a report that was in court was the question being asked, but it wasn't. And I figured it still conforms with the way we operate, because ultimately we regulate the activities of the Parliament here, and any decision wouldn't be one being forced by the judiciary, but one taking into consideration some amount of deference to the fact that an issue is in court and making the decision here at the Parliament how to treat with same. So,
and this goes all the way back to the Bill of Rights in the 1600s. This is sort of a core kind of principle of Westminster-style democracy, which is, judges would never be checking whether the House's internal proceedings are right, correct, but there is always that relationship with the Constitution itself, and I think that's that point. Is Parliament sort of overstepping its mark and taking powers that aren't subject to it? Its powers are relate to its regulation of its own work rather than the work of others. So aside from through legislation, but then when that legislation is passed and that goes into the legislative sphere and then can be ruled upon by the court. So it's that separation of powers hopefully working effectively. Well, and again,
Sean, with one exception, if there are decisions taken by the chair that breach the constitutional rights, any breach of constitution, that is when the judiciary, appeal to would more likely than not, as indicated by Member Malahou, really take, a keen interest in our activities and whether or not we are in breach of the constitutional rights of any individual or body of individuals.
Yeah, absolutely. And hopefully that's clear. And again, this is something that I think we spoke about this when I was in Jamaica, that, my expertise is broad. and grounded in Westminster, UK, but with a broad experience from sort of working across various Commonwealth parliaments. But this is why it's so important that it comes into committee for debate and discussion now, so that your expertise in the kind of in the legal sphere of Jamaica specifically, and of course of which I'm not specifically trained, can come to the fore, and you can make sure that these points are really clear. And it's why, yeah, this is the jumping off point, and hopefully it's an easier jumping off point than it would have been previously, because I've come at it with that sort of impartial clarity, make it easy to work through and amend and discuss. But that's where the expertise comes in every time. So yeah, I wouldn't answer for your specific domestic circumstances, I suppose. It was a simple way of saying it.
Thank you. An intervention from Member Paulwell?
Yes. Sean, just one final question from me. But before I go, it's just clear that you're not a football lover, because you would not be on this call if no, Argentina won 3-2. 3-2. So I hope I'm giving you news from Jamaica.
Well, I am a football lover, sadly, but you know, I'm also a lover of standing orders. So you know, when your two loves meet. Anyway, sorry. What was the question?
So I'm trying to look at the overriding principles that govern the operations of Parliament. And I know that there's always the basis of the principle of reasonableness in terms of how we interpret these standing orders, even-handedness, and impartiality. But I'm wondering if there is another principle that seeks to, in promoting democracy, seeks to promote, even as you go for even-handedness, the interest of the minority over the majority. There's a principle in companies law and Foster and Arbuckle where there is always if there is erring, to err in favor of the minority. Is there such a principle that guides the standing orders and their interpretation across the Commonwealth?
There is absolutely, and that is an area which, again, is often ruled on by the Speaker. So, I mean, you'll see, for example, well, you won't see of this, but if you were to go to arrangement of debates and how debates need to be organised, there are at least two provisions that I can find quickly about sort of adjournment debates. Adjournment of debate should be put immediately unless the Speaker rules that they're an abusive procedure or infringe on minority rights. Again, on closure of debate, should be put immediately unless ruled to be out of order or infringements of the rights of the minority of members. So yes, there is a fundamental principle that control of time really is governed by the business. It's the elected government, but there should always be due regard to the role and rights of the minority parties in the House. Again, it's why you have an official opposition. There are certain rights afforded to these sorts of things. So, yes, there is, and it's not just in Jamaica. It's a principle Commonwealth-wide.
Sean, I would want to make sure that we also clarify Jamaica is a little different. We have two-party system almost. Many of the other countries have several minority parties. And I think we need to be very specific about that, because I hear the question, and I had a practice when I just became Speaker of giving significant deference to the opposition. Yeah, absolutely. No, I can tell you. Whether or not they felt it, knew it, or understood or appreciated it, and I'm going to give them specific examples. This current budget debate, the standing orders allow about 75% of the amount of time allowed for the government, for the opposition to respond. In this last debate, it was 50-50. As a matter of fact, by the time we were finished, I gave more time to the opposition than the government, but they would not have appreciated same, unless it is said to them. And I took that stance going along. But as a system, as a system, in the amount of speaking time, no, man, I could have done that, but I didn't. I didn't reduce the opposition's time.
I mean, there are a lot of provisions within the standing orders that protect the role of the opposition.
What happens when you get to a system, Sean, where it is a two-party government, meaning government and opposition, and there is no real minority group? The opposition.
Well, I mean, the official opposition becomes the official opposition becomes, you know, by virtue of not being the government, is that smaller group. So it's not necessarily 2 or 3 people, although it might be. But, you know, I mean, the things are slightly different in the UK now, but for all intents and purposes, it's been a pretty solidly kind of two-party system for a long time, Conservative and Labour, and things go up and down in smaller parties, and we do have them. But you still have this official opposition, and it's the roles and rights of the official opposition, and that is, throughout these standing orders, very clear, you know, where they need to be consulted, where they need to be, so it's really clear throughout that.
Very clear.
I mean, arrangement of debate, and I think maybe this is not necessarily for the procedure committee, because I think we've talked about this a lot when I was at the seminar, and also we were talking about it now. But that's very much about a kind of a culture discussion about when you disregard standing orders, how long people take. You know, standing orders can only do so much. Standing orders will never, they can't make people, particularly when you can disregard them and you're willing to do so. They're not the fix-all problem, but the point of this exercise was to remove them from being another potential problem, if that makes sense. So you're debating less about the standing orders because they're clear and everyone's agreed on them. Time limits is a difficult one, because as you say, you set a time limit and that becomes the ceiling, and then people push up and up. There are different ways of doing it. I mean, in the UK, for example, there is a little bit of an understanding of how long people speak for, but what will generally happen is the speaker will set a time limit for everyone. Now, that's different, and it's not something that would happen, but they might say, everybody, I can see there's 30 people in here, and we've got however long, so I'm going to give everyone 5 minutes, or 10 minutes, but, you know, or 50 minutes. But that's a different system, and that's a big change. So that's where you kind of, as a procedure committee, you can think about how you want that to operate. But again, it also relies on people sticking to those time limits. So yeah, it's again that point around how far can standing orders actually go. They could only go so far, but then it becomes a decision for the members of the House as to how they want to conduct themselves vis-a-vis those standing orders.
We have some more intervention, Sean, when you have a chance. Member Buchanan, then Mallow Huford, then Member Brownberg.
Thank you. Sean, I'm bringing your attention to clause 25, which is a new insertion. That would be the sub judice clause.
Yeah.
Now, there is a definition of sub judice in the definition section. And it simply says, for the purpose of standing orders, and I'm going to assume it says XX, but whichever one, it refers to a matter that is before the court and awaiting adjudication. Now, the problem I'm having is we have not codified, but what is understood to be the doctrine of separations of powers. Yeah. So sub judice, as I understand it, the object and purpose of the sub judice rule is that the litigant may be affected because the matter would be going before a jury. What happens here, and the court has pretty much decided on what sub judice when it is that you breach a sub judice rule. And if matters are going before judges in civil jurisdiction, then those matters would not be sub judice unless a judge indicates that you're not to speak on the matter. But certainly there's in clause 25, it sets out for the purposes. It defines sub judice differently, and I'm wondering if it's to be called that because it's not operating as sub judice, and it actually weakens the power of the court. It sends a message that judges are influenced by matters outside. When we have rulings that is distinct, judges say Parliament can conduct their affairs as long as it's not repugnant to the Constitution, as well as the judges, they rule as if nothing is happening. The court of public opinion, it is assumed and perceived that when judges rule, they're not affected by outside influences. Yeah. So it kind of sends, so I need to know whether or not the doctrine of separations of powers was considered here, because it appears to be, well, my submission to you or to the host is that it's a bit problematic. If it's something we should revisit.
I take your point, and I think, again, this is one of the areas I highlighted on the way through, because it's one of those areas that you're wanting to discuss. What you have in front of you in the main thing, and I think the definitions, that they can change, but I'd focus on the main orders. That is, give or take, the kind of UK approach, but with regard through discussions to what I consider to be the Jamaican domestic context. If I take what you're saying correctly, it's that there's sort of an assumption that they wouldn't be influenced, and so it's not a problem, and it need not necessarily be said. And apologies if I've misunderstood you. I think this is about what Parliament does. So this is Parliament saying to itself, we will not. So we're demonstrating our respect to the separation of the courts, that we won't seek to unduly influence. I wouldn't say that it suggests that they would be, but equally, it just removes that possibility. So they shouldn't provide the opportunity to comment on something that's ongoing in the courts, because it could fuel speculation, or you could be using politics to, even if it doesn't change the judge's opinion, to influence public opinion about what that opinion would be if you're anticipating you're not liking it. So again, these rules aren't aimed at anyone in particular, but this is a pretty standard provision that's used in many jurisdictions, and it's one that I put in there. But similarly, it's one that would definitely need to be discussed for people who have considerably more experience, to say the least, of your domestic context and how that works. So again, I think, as I've said, I've presented what I think is a workable, clear best practice, but it is for the House to regulate, and you are, in this context, the House, and can discuss that. So hopefully I was clear in what you were suggesting.
There's a follow-up from Member Buchanan, and then a follow-up from Member Green.
Thank you. You were, Sean, it's just there is the constitutional implication. Because I don't know if it was considered that as it is written, it is just clear in breach of the Charter. So we're including...
it's not... So I was going to say, it's not something that I intended to do.
Right.
It may have been an accident that arises from my lack of understanding of the Jamaican Constitution. I've read it several times now, but you guys are, many of you, I'm sure, in that room, scholars of it. So please, where you see a contradiction or an issue, that's exactly where your insight and expertise is welcome as the procedure committee.
Thank you.
Yeah. So. Thank you, Sean, for your presentation. I think it's excellent, and for the work that you have done in putting this together. I wanted to pick up on this point, because I do believe that in the move you've made in 25 has brought a significant clarity to the underlying principle that we have been practicing. And I, for one, as you have said it, and I know it will engender a lot of debate as we go through looking at our new standing orders, but I, for one, believe that clearly Parliament can say, by way of rules, how it will treat with these matters. And I would say, I will go further. I would say Parliament should say, so that it is not left for one to determine based on the matter that is before the court. Because I think the fact that a matter has been brought before the court, and I always believe that the overarching spirit of the standing orders have always been that Parliament should not do anything that, whether by way of perception, directly or indirectly, frustrates the process of the court. And there are a number of things that can be done in this House, especially because we are covered by a broad privilege to speak extremely freely without fear of prosecution on any matter in this House outside of what is excluded. So I think clearly excluding these matters that are before the court and saying it up front so that it is known makes a lot of sense. But I know we will have a lot of discussions about it. It is a very topical issue. But again, I think sometimes we have the discussions because, you know, I think the reforms that we're making with our court system to ensure that these matters are dealt with expeditiously will also help in relation to ensuring that Parliament does not frustrate the process of the court. But thank you in general, and I'm sure we will have robust debate on some of these provisions. But I do not think it contradicts the Charter at all.
Yeah, and as I said, I mean, it's a prohibiting. I suppose it's a prohibiting output as opposed to a consideration of input. But yeah, thank you for that contribution. But as I said, I'll defer to the legal expertise, of which I know is voluminous in the room, to work out the exact issues with it.
Member Malahoo Fort, if you still have your intervention.
Madam Chairman, I wanted to just go back to the issue that was raised about the minority voice and the provisions in the standing orders. I believe that we should be careful not to conflate an issue of privilege with an issue of how decisions are taken in a democracy. Because in the democratic process, it is a majority voice that carries the majority vote. And you see that provided for constitutionally and in the regulations by how a vote is taken. And that is always how it is determined. But then there is the issue of privilege, which protects the right of each member of the House to participate on equal footing in the debates. And those matters, if a matter of privilege arises, it is to be treated in priority to all other matters, because that, in effect, how it is resolved will determine whether a member is being obstructed in his or her rights and powers as a member of the Parliament to carry out the duties. So I think we just have to be mindful that there is a difference between the two, and the proposed rules must also clarify that matter. An analogy of minority rules under company law would be unhelpful for these purposes. Just right.
Yeah, no, it's certainly not that, you know, as you say, I think, and I maybe wasn't clear enough, the fundamental point is that the majority wins the election and therefore has the power to implement its will, and actually the things that are given to the opposition are in many ways given. So, you know, the opposition to contribute, but they are given in the standing orders, and the House agrees that there are rights that under the House's rules, the opposition has to contribute in certain ways and to be consulted in certain areas. And hopefully I've tried to include those in the most appropriate way. But again, for further discussion, I'm sure.
Member Bromberg.
Thank you, Madam Speaker. I realize that we don't have much time to go, so I want to add my own thanks to Sean for all the work that he has done and for today's session. Just quickly about 25(2)(b), for example, in today's current environment, no, the new 25, which is the same one about the sub judice matter, renders that whole standing order a real joke, because what you end up actually doing is allowing an individual member, for example, who is the matter of an issue that may come to court, to actually put it in court so that the Parliament then would not be bound, if this were to come into effect, the Parliament would then not be able to actually discuss the matter. And I believe that that would be a travesty of justice and an abuse of the privilege of Parliament in passing such a standing order. So that's one. I also wanted to ask Sean about two things. Let me start with one that might be less contentious. The leader of government business and the leader of opposition business, whose roles are not fully developed in the standing orders. I believe that there must be some other jurisdictions where we have a greater appreciation for the role of these two individuals. And I think that as we look to amend the standing orders, that is something that we need to look at. How can we make sure that their roles are clearly defined and that they have, what is it now, the right of reply in some instances, for example, or that they are codified. So I'd like to have your opinion on that. Secondly, in terms of, I'm pleased that we are looking at the role of the speaker in particular and looking at that. I believe, though, that currently the speaker has too much discretion, and what happens when discretion is so large is that you, at some point, no longer discuss the rules, but you discuss the speaker, since it is the speaker's discretion. I believe that one of the things we need to do is to remove that large discretion and codify how certain decisions are to be taken so that we can begin to be more objective. When there's a loss of trust, when there is a feeling of bias, it is important that the speaker becomes an individual who implements the rules, but doesn't make them up as he or she goes. And I believe that that is one of the things, as we go through this, that we have to make sure that we do that. And coming back to the issue of government versus opposition, the role of the speaker in being an fair arbiter of the conversation and the discourse, I think is an important one that we cannot continue to diminish.
Okay, I'll respond to both of those in kind, if that is helpful. So on the role of the Leader of the Opposition and the Leader of the House, so those are now defined quite clearly, I'd hope, in the general definitions at the end. So I don't know exactly what page it's on, but in the full draft, we have quite clear about Leader of Government Business in the House and Leader of Opposition Business in the House, who they are, what they are, and then they're referred to quite extensively through the standing orders to explain, you know, what they do and the role they have in each of those situations. So hopefully that is kind of good news from your perspective on that. On the speaker and the role of the speaker, so, you know, naturally I won't get engaged in concerns over, you know, individual decisions or debates that are taking place, because that's not the role of the standing orders or me. The role of the speaker is to implement the standing orders, and one of the points of this exercise was to make the standing orders a lot clearer, so there was less debate about what wasn't meant to happen. So I would hope that an outcome of this would make everyone clearer, you know, in terms of the easier structuring, the process-driven approach, the simpler language, the updating to processes so that everything is more explicit. So even on the point, I can't remember exactly what it was we were talking about before, I think it was suspension of standing orders. There are now 2 additional bits to that, which explain how that would happen in practice, rather than just, oh, they can do this, here's the process by which they might do it. So I think those would be my 2 answers, really. The definitions are there, and if you want to discuss tightening them up or making them more explicit, very, very happy to do so, or defer to your expertise on that. And then on the role of the speaker, that this is the speaker's role is to rule on the standing orders, and I think the speaker, you know, in place at the moment, was keen to make these clearer so the rulings could be clearer. But again, that's it's probably not something for me to get too involved in, aside from making those rules as good as I possibly can for all parties in the House.
Sean, thank you for that intervention. I will reiterate in closing, we're at 1:30, that as a committee and as a parliament, we do appreciate the work done over the last year or so. Initially, the perspective was that it was only being driven by the speaker, and the speaker is adjusting the standing order to the current speaker's suit. It was not the case. Yep. And the commentary and perspective that you can codify the standing orders to remove the power of the Speaker is never going to happen in any jurisdiction. There are always going to be, there's always going to be the need for the Speaker to be the umpire and the chair in a committee to be the umpire over the activity. So we are making every effort to codify, to clarify, to make as detailed as possible the standing orders to ensure that those of us here as parliamentarians understand it, and even for the benefit of the public, they understand as well. That is very important, so that when decisions are made, we are absolutely clear this is what the standing order calls for. The Speaker benefits from it, and every other member of the House, and every member of the population who has the interest in looking at how we administer our affairs. And that is why we embarked on this process that, as I said, we have not done in a long time. I cannot overemphasize the contribution made also by the current clerk of the Parliament of Jamaica and the legal officers of the Parliament of Jamaica and the team here, because the administrative team sat down with Sean and did the majority of that work and came to present and to ask questions initially of the Speaker, and presented a draft which we are now looking at and interrogating at the committee level to move on from here to our entire Parliament. I must say, Sean, it is instructive that member states right across the Caribbean Commonwealth have been in discussions. Speakers from across the Commonwealth have been in discussions. They've actually asked us for a copy of our draft. We have said, let us finish the process and then we'll be happy to share, because they are taking note of the process we are engaged in here in Jamaica. And I found it strange because even Trinidad and Tobago said they want to take a look at what we are doing. They do not want to be reinventing the wheel. And as a parliament, we are very happy once we complete this process to join the pool of Commonwealth countries who can be used as a talking point, as the standard, when you're looking at what our best practices. We would love to hear Jamaica is where we will look to best practice in terms of its standing orders. The Senate for the Jamaican House of Representatives they recently went through the process. They continue to look at their own standing orders, and we're looking forward to sharing this with them once we're finished, because we thought we could benefit so much from looking at the amendments made by the Senate. And now that we have gone through this process and seen how you have organized us and the mechanism and the flow, it is so much easier now to understand and to follow the standing orders as they are redrafted, that I believe our own Senate will benefit from what we are doing in the House. We thank you for the time and the effort, the contribution, the level of research that has gone into this process. And we are committed to ensuring that in this current session of the Parliament, we are able to get this done and implement our new and updated standing orders, which will better guide our proceedings. Thank you very much on behalf of myself and the administrative team of the Parliament, and I dare say all our membership of the committee. We are most grateful. Thank you.
Thank you as well.
All right, I know we are almost out of time, or probably out of time. Is it possible for us to adopt the minutes at this time?
I have two corrections, Madam Speaker. On page 1, paragraph 3, an apology for lateness instead of absence.
Yeah.
Minutes of the meeting of the Standing Orders Committee So to
yes,
amend,
we will take that correction.
To delete
yes, you
the
did
word
come in.
absence and
Yes.
substitute with lateness, and to remove.
No, it's not correct at all. What we're going to do, we're going to remove it from apologies, and it needs to go into the attendance section. So it will be so corrected.
No, it is there, Madam Speaker. An apology.
Oh, yep,
Yes.
so corrected.
So it's just on page 1.
Thank you.
And
Noted.
where a
Next.
hyphen appears in the name,
Lord Jesus,
between Malahoo and Forth, to be deleted on all pages.
Thank you very much, Member Malahoo, for that correction to your name. So remove the hyphen. Thank you.
Having
Member
read
Paul,
through.
you have a correction? You have another one?
So I'd like to move for the confirmation of the minutes and to raise one matter
As
rising.
corrected.
Anything in
As
here?
corrected, yes.
Yeah.
Just one matter rising. Yes, yes, sir.
So I will take the mover for the adoption as Member Paulwell, seconded by Member Malahoo Ford, and Member Paulwell has a matter arising.
Right. Madam Chair, we had inquired at last sitting to enable us to be able to deal with our caucus, whether or not we can see a soft copy.
I spoke to you privately. We're still having a challenge in terms of stamping draft across them. Even today, we were having a challenge, just printing. So I'm working on that. Yeah, only the first 4 pages we were able to do. And I do not know why. So I'm going to take the document myself and see, even if it means copying it into some other format, more updated format, to see what can be done. How many pages? Is it 4 or 5?
It would therefore delay our...
Yeah. So how many?
Man, you can proceed, man, on the honor of members.
Oh, Member Paulwell, what the clerk of the committee is saying, the copy you have is the copy for the file, for the records, and he has not been able to duplicate that process. We are having some challenges, technological challenges. So I'm going to see to what extent we can go further, because it is more efficient if we're able to do so. If not, we push ahead with this in the interim. Member Malahoo Ford?
May I propose, Madam Chairman, in the interest of time, that consideration be given to releasing the draft document on the honor of members, so that it be treated as a draft in the absence of the watermark.
Yes,
On
I think we
members'
were able to
honor,
get a
on the
watermark on at least the first 4 pages of the draft. We were able to do that. Okay, so, all right, so I think that will go well for all members. So if we don't have any objections, we will do so. All right.
I'm happy that has happened, Madam Speaker, because it brings us to the issue of homework. If we're going to be able to complete this, there are some significant, the comprehensive comparative analysis is an excellent roadmap, which is user-friendly for all persons. So I'm assuming that there are some hot topics in 2026, which includes dress code.
The dress code is wide. It includes visitors to the parliament.
I know, but
and it includes possibly deciding that we would like to wear Bermuda shorts instead.
Well, maybe only in the summer, Madam Speaker,
No,
but certainly that one aspect of it, as well as the interpretation section. I'm just calling it out on record so that in terms of clause 2, what interpretation looks like, even with formalities, because that's going to be significant moving forward. I do think that the structure is a lot much easier and user-friendly and should be able to understand, but there is going to be the issue of interpretation, and so on a matter of homework, if that's the best way to use it, that I'm just encouraging members here to read, as well as the document is released, we actually have other persons, other members to look at it to give their contribution.
Thank you so much. Appreciated, and we so will. The item of interpretation at clause 2 is literally to minimize the need for us to interpret. That is really what it is. It is making the language easier, more foolproof in the average individual reading and understanding the very same thing. So it is not left to high science, legal luminaries, and the speaker to be able to interpret. So that is the intent at this segment, and we will benefit from it. I know that some members jokingly cite standing orders and interpret them not in the way that they know the average person would. I don't know, the individual is laughing at himself. But I know you actually quite get and understand, because we have had the discussions, and every effort is meant to do so. I remember citing to Member Brownberg that when I read the standing orders the very first time, how I operated with questions and answers to questions was tighter than how I do now. Because having read it again and read it again, I'm saying, no, I think I can give some more leeway, which is what I do. I give far more than I say loud. Yeah, so I before we used to cut off at 5-6 persons. I remember when in my last jurisdiction, now I allow everybody to ask questions, particularly because it benefits what you would consider the minority. So deference has been given by me as speaker and chair. No, seriously, to ensure that there's a balance, to give the opposition as much, opportunity to partake. That is usually very appreciated, but God help me the day that I said no. But every effort is made. But when you say no, and so we have to start to get, so when you say no, you have to still work with the speaker in the same way as when the speaker say yes. Thank you. All right, so members, let me say thank you. The adjournment has been so moved and seconded, and we will do our homework. We will do our homework, and then we will come back, yes. So moved and seconded, members Malahoo, Fort, and Paulwell. Thank you so much. We should be back in short order for today's sitting of the House. Thanks again.
No, I said, place when you come from, brother, I want to live good, man. I want to live good, brethren. No shake on, I can play a little ball, brethren.
Really have to shake on?
Yeah, man, and no badness, brethren. Just live good, man.
Hi everyone, here are 5 benefits of being a beneficiary of the Students' Loan Bureau. 1. Benefit from our 99% approval rate. 2. Benefit from our low interest rate, so less burden when you need to repay. 3. Benefit from the fact that we require no collateral when applying. 4. We're giving you more time to focus on your studies while we focus on the financing. No need to worry about repaying while in school. Number 5. Receive a 14 months grace period after your graduation date before you enter repayment. Don't forget to follow us on all SLB platforms for more SLB info.
The following is brought to you by the Office of the Prime Minister.
Your government is empowering you through education, training, and development. That is why we have removed all fees for every Jamaican accessing training through the Heart NSTA Trust. So, whatever you desire training in, food and hospitality, beauty and cosmetology, housekeeping and hotel management, welding, carpentry, masonry, or any of the dozens of programs Heart offers, you can enroll completely free and change your life. We are building Jamaica.
The proceeding was brought to you by the Office of the Prime Minister.
Are you an entrepreneur producing an excellent Jamaican product or service? Did you know you can earn hard currency and more significant returns by exporting? Contact the Ministry of Industry, Investment and Commerce to help propel your business along the export lane.
Everything you can produce, the Jamaicans overseas want it. We're not going to get rich by just bringing down the debt. We're going to get rich by exporting a lot more. So grow exports, create job opportunities, drive economic growth through exports to make Jamaica a richer and much more prosperous country.
From seed to sail, Jamaica's future grows through innovation. Introducing Export Jamaica, a global market intelligence and compliance gateway that connects your effort with global opportunities and makes international trade easier, safer, and more convenient for Jamaican businesses. Powered by the Jamaica Trade Board Limited, Export Jamaica is designed to position your products competitively and guide you through international trade. Find high-demand international markets. Gain access to trade analytics that guide your business decisions. Identify and engage with potential buyers. Know your costs up front. Trade confidently. And keep your exports safe and secure. Through Export Jamaica, you can discover all there is to know about exporting and grow your business sustainably.
From the processing of your goods, to packaging and shipping, to seeing your products reach international shelves and enjoyed by customers abroad, Export Jamaica provides the market intelligence and insights behind each step, helping you identify demand, understand export pathways, and unlock financial growth.
Say hello to a prosperous future. Visit tradeboard.gov.jm/Export Jamaica to sign up today. Expanding Jamaica's reach, empowering our people.
Jamaica's first broadcast museum is completely online. The PBCJ Audio Visual Library AVL website houses a curated collection of exhibits ranging from